Where'd you come from?
I came from North Carolina.
Oh, wow. Okay. You drove or flew?
Flew.
Okay.
We lived up there and predominantly just do public law and then come down here this close to here we would drive or fly.
Okay, what part of North Carolina?
Asheville.
Asheville? Are you okay after the flooding?
Long story.
I love Asheville. I've been there a handful of times, years ago though, but it's devastating.
It was, I mean, I have stories that people are like, no way that didn't happen. Kind of, I mean, it would take me a while, but it was brutal.
Yeah, I'm actually going to Highlands, North Carolina for a wedding in 2 weeks.
Oh, nice.
Yeah, and I was going to fly into Asheville, but now that's not
Yeah.
an option anymore.
Yeah.
So I'm actually driving from Tallahassee. I know, but by the
So
time
we got 75, right? Maybe about 75.
I don't know. By the time I was trying to figure out, like, changing my flight and, like, fly out of Atlanta or where to fly out of, I was going to have to rent a car anyway. And it was going to be the same, if not more travel time.
Yep.
Depending on when the flights were going in and out, you know what I mean? So I was just like, honestly, it's faster for me to drive. It sucks. It's pretty far distance, but.
That's why we do it sometimes. If we have to go to Orlando or even here, we look at the flights. Like, I should have drove tonight. I can't get out until, I won't be home until 1.
Right, that's the thing. Yeah, there's not so much flexibility.
Yeah, exactly. And then I flew Legion here and then Delta on the way back because everything's messed up still. But it was, my neighbor had the trees falling on them while she was taking a shower and had one of the branches punctured through her lungs. We have a neighbor that was a doctor that was running around trying to save her life, and all the trees were down so nobody could get out. She ultimately lived, but it was just chaos.
Right.
People were drowning in their homes because they didn't know the flood's coming. Like they're finding appendages on the trees.
Right, it's like the apocalypse.
It was crazy.
It's hard to even imagine.
Yeah, I mean, we were washing our baby in a bucket of water outside on the back porch for a month because we didn't have
For
water.
a month? Wow. Oh my goodness.
No power, no anything. It was like, all right, we're back in 18
Right.
minutes.
It's like the world's ending.
Yeah, it was crazy.
Yeah, that really is. Oh, I'm sorry.
I mean, you learn what's important and things like that. You also learn what it's really like when you have to.
Yeah, fend for yourself.
Yeah. I mean, my friend's neighbor actually shot and killed somebody that tried to break into their house.
Wow.
Yeah, I mean, it was clearly self-defense. It was some guy that was fiending for some particular.
Right. That's the thing. All the crime that comes with it, the aftermath of those natural disasters.
It's just like, come on, people.
Right.
So, yeah, we have a full gamut of weird stuff up there. It's just never, I mean, some of the towns are gone.
So are you still in your house?
Yeah, luckily, the only thing that happened to us was all the trees went down. We were off a little bit from the river, but the river just sucked everything away that was near, like, 10 towns are gone.
Okay.
Yeah, it was crazy.
Wow.
Yeah, so it happened 100 years ago, and people are just rebuilding back in the same spots. I'm like, okay.
Right.
It is.
Right. It's a cycle.
Yeah.
been here for that long, so maybe I'd rather call it.
All rise. Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Adrian G. Sow, Judge presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Counsel, good morning or good afternoon to both of you. We have one case set this afternoon for oral argument. That is case 23-2900, Smith versus State. We are set for oral argument. 20 minutes will be allotted each side. It's our customary practice to provide 5 minutes for rebuttal, but of course that's your choice. If you prefer a different time, if you will just let us know that when you begin your closing arguments, we'll provide whatever rebuttal time you request. Obviously, if I could, for those who are here with us in the courtroom as well as for counsel, if you'll ensure your cell phones are off so as that we not disturb the proceedings, we would be grateful. And with that, counsel, you're welcome to proceed on behalf of the appellant.
May it please the court, may I reserve the 5 minutes that you suggested, Judge?
Yes, sir.
Thank you. I'm Rick Sikta, and I represent the appellant, Mr. Smith. The Florida Supreme Court, since 1951, said that a trial of one charged with a crime is the last place to parade prejudicial emotions or exhibit punitive or vindictive exhibitions of temperament.
This court has followed that rule of law consistently since the 50s. This court has reversed prosecutorial comments that disparage or villainize defendants in Rodriguez, Stafford, which was 2024, Brinson, Crew, Freeman, Sempier, Olson, Silva. This court takes a hard stance in all those cases. The Attorney General's office, my opposing counsel, has suggested that all of those comments were proper, and they take the same position in this particular case, even though there are at least 25 improper comments that we have.
The comments, and just so I'm clear, because there was some back and forth in the briefs, as far as the comments made by the state in closing arguments, were any of those objected to?
The comments were not objected to.
So we're under a fundamental error analysis on those statements. I know you have some about other people, the other testimony, but as far as the statements and the closing arguments, none of those were objected to.
That's absolutely correct,
Okay,
Your
thank
Honor.
you.
Yep. And the other comments that were objected to deal with the detective's personal opinion in interrogation, that the accused, my client, was lying to them, that the evidence suggested that he was a killer. And those comments were objected to, most in part with a motion in limine. And as we explained, the Jackson case in 2012 condemns those types of arguments by a lead detective for obvious reasons, because the lead detective is seen as this authoritative figure by the jury. And so in Jackson, they said that those comments can come in if they elicit some relevant response. Here, and this is the problem with the comments and the detective's opinions, here we have a defendant with no prior record. He is serving our military. He has a job as a general manager at Dodge Asboro before he comes to Jacksonville to try to find a new job. He secures a job with an automotive agency. He has no prior instances of abuse. He has a 9-year-old son. They do not have anything bad to say about this guy. And I think this is the critical issue in this case, because if you read these closing arguments, what are they designed to do? They are designed to villainize this client. Your Honor, you have said recently in the Baroni case that the jury is this sanctuary, this noble duty. But when you take a jury and you give them kid games and villainizing throughout the entire rebuttal closing argument, you erode the fundamental fairness of this trial.
And if you point to one specific comment that by itself is fundamental error, are you arguing just as a total cumulative effect?
I mean, cumulatively, they're enormous. And if you look at
nothing, you can't say just one comment by itself is fundamental error. You would have. I think what you're arguing is cumulative. Is that correct?
Yeah, I don't want to stretch and ruin the credibility of the argument. I think that some courts would find some of these personal opinions that we know he did it or he left the scene of an accident because he's guilty. I mean, those are personal opinions by a prosecutor, general or personal, that are very, very close to fundamental error that courts have.
Implied is evidence of consciousness of guilt, though.
Exactly.
So could not the prosecutor's rebuttal argument be just that they're allowed to infer guilt from his flight?
Absolutely, in the appropriate ways. They can't say we or they or we, insinuating that the court, the police, and the witnesses understand that. That's what the case law says. You're allowed, in closing argument, as you know, Judge, as a former prosecutor, wide latitude. But that latitude cannot cross those lines. You cannot insert personal beliefs, which was littered throughout this rebuttal closing argument. My opponent makes the argument, well, it only occurred in rebuttal. But if you look at the Brinson case and the Rodriguez case, that also occurred in rebuttal. And I would argue rebuttal is even more prejudicial because that's the last thing the jury's hearing.
The lion's share of the comments you object to were in rebuttal, right?
Absolutely. Yeah.
And so what relevance is it to us that, and you reference, I think, repeatedly in the initial brief, the reference to the appellant as Brandon.
Mm-hmm.
And what relevance is it that defense counsel during trial and during her closing referred to the appellant by his first name, or then the defendant by his first name?
I think it would be fair game if the prosecutor did the same instead of villainizing him and mocking him as poor Brandon. Oh, poor Brandon, look at him, so hard on Mr. Brandon. I mean, she took it to the other level that the case law prohibits. And I know in our Fourth Circuit...
Was the purpose to mock him, or was the purpose to draw a distinction between you have to disregard numerous witnesses, devastating injuries, other physical evidence in the case in order to conclude that his defense is sufficient to lead to a verdict of not guilty?
I mean, in context, it was clearly to mock him. I mean, if you let me have a moment, Your Honor, just to read some of the things in context. She says, this is what the defense wants you to believe. Whether he teleported, I don't care. Oh no, it's not Brandon's fault. Give me a break. Really? It doesn't take a rocket scientist to figure this out. Convenient, right? Everyone is just scaring Brandon. How hard this must be for him. Geez, everyone is trying to scare him. Heard of HIPAA? Are you serious? I mean, those are gratuitous comments that have no place in our courtroom, Your Honor. These are kid games. And if you look at the jurors' deliberations, in particular the questions they asked, they were curious about Mr. Smith's credibility. They wanted to see the 911 call. He called 911. He ran the child to the hospital. And they wanted to see what was in his suitcase that he was packing. And Mr. Smith said he was going back to the hospital. If anybody's had an emergency with their loved one or a child, that was my role, is to go home and grab a suitcase and come back for the mom. So that's the issue here. And the fact that there were 25 improper comments that it took a quick Lexis search of 5 seconds to find cases that were just littered in the 5th DCA and the Florida Supreme Court. And these were fundamental error cases because of how bad and how pervasive these comments were. And they went directly to attacking him. And then to your point, Your Honor, well, did he leave the hospital? Can they comment on that? What the state was also doing is saying people don't flee from accidents. What's the statistics on that? I mean, that's not a fact in evidence. And that's another issue with it. This is what we know happened. This was not an accident. He did this. Why are they calling 911 in the first place? I don't know, because he beat her to death. He left because he's guilty. Everyone thinks you did it. I wonder why. These are all in the rebuttal closing argument, gentlemen. So the cases and the burden shifting was another issue where they say you have to believe, in order to believe the defense counsel's argument, you have to believe that all the witnesses are lying. You have to believe the police are lying. The prosecutor went so far as to say, oh, it's the hospital bathroom's fault. I mean, she was getting that childish to say it's the bathroom's fault. It's AW's fault, who's the minor victim, who's deceased, and they were just commenting. And then we cite the cases, Freeman, which was from this court. The prosecutor in that said the question is who you are going to believe. And the problem with that, if Your Honors haven't figured it out already, reasonable doubt is not who you believe. Reasonable doubt is taking all the evidence dispassionately and compassionately and looking at it to see if it proves the essential elements of the crime. And she did that in this particular case 3 different times as to shift the burden to say, if you're not going to believe these people, then he's guilty, or he's not guilty if you believe these people. That is the burden shifting. We quoted Freeman from the 5th here, 1998, Cluis from the 3rd, Gore from the Florida Supreme Court, Atkins from the 3rd, Covington, which said this case came down to who the jury believed. So you have clear, and these are not ambiguous, these are codified in the case law. And as a matter of fact, the state also mentioned in their brief that, the judge commended opposing counsels for their work in this case. But if you look back at Judge Berger's, former Judge Berger here, her opinion, her concurring opinion in Crew, she says it's also on the onus of the judge to understand these. So I encourage this court to issue an opinion reversing this case because this is a very close case. I mean, this man...
You would agree Crew is entirely different than
Entirely
this case.
different. I was just referencing the concurring opinion saying everybody that's in this courtroom, in this trial courtroom, has to be on notice for any kind of misconduct and object. And if there was a trial court judge that is seeing this, I think Judge Berger's point is we all have to stop this, because what happens when this happens is we have to do this whole thing over. The victim's family has to come back, the defense comes back, the taxpayers are paying extra money. And so...
Does this case get even close to the facts of Crew?
I don't think so. But I think this case is close because you have all of these good things about a defendant, and then, the police went in there, Officer Sermon went into this hotel room, and there was no evidence whatsoever of a struggle. Nothing. And that's shocking, considering that the state's theory was this child was beaten with blunt force trauma. And there's no evidence of that. The only evidence they found was a speck of liquid that tested presumptive positive for blood that was found on the pillow, which is exactly what Mr. Smith said happened, that she bit her lip. And so he was telling the police, go look in the garbage, you'll find the popsicle stick. He voluntarily waives Miranda. He wants to talk to the police. The thing that really, in my 20 years of doing this, it's very hard to maintain a story when you don't know the story is being recorded. There was an uncontrolled call, and then there are two detectives interrogating him. Both starts off the Reed technique, developed in Florida. It's an accusation technique that the police use in the States. It's switching a little bit now, but so they start off soft and they get harder and harder. His story is exactly the same. And he didn't even know that he was recorded in the controlled call, and that's surprising to me. And then after that, he's like, give me a lie detector test. And so the reason why the state had to employ this tactic, and the intent is there because the volume is there. If this was one or two, I wouldn't have a credible argument. I admit that, but these are high-level errors, and they are designed to convince the jury that this defendant, who has nothing wrong with him, is a villain. And with that, Your Honor, this is one of the fundamental error cases that this court repeatedly reverses on. It's a close case. The jury did not find premeditated murder. They came back with felony murder. Like I said, they had 3 jury questions, all, in my opinion, designed to test the credibility of this particular client. And this case should be reversed with instructions to stop this, because this is the second one that's happened in this year. Stafford was the other one by... Now, I will give credit that there was 2 prosecutors here. The first prosecutor, her first closing argument, there was nothing wrong. It was professional. But this one crossed the line on multiple instances, and the case law backs it. Your Honor, if you don't have any other questions, I'll end right now.
Thank you, sir.
Yes, sir.
Yes, ma'am.
Good afternoon, Your Honors, and may it please the Court. My name is Sheena Kelly, and I represent the appellee, the state of Florida. We respectfully request this Court to affirm the trial court's judgment and sentence because the defendant was not deprived his right to a fair trial. During my time before the Court today, I'm going to start with why most of the comments were proper, and in the alternative, there was no fundamental error given the strength of the state's case. I want to start out with Judge Boatwright's question regarding the coagulation. So, in fact, it was objected to. That's on page 1300 of the trial transcript. It was objected to, and then the judge overruled it. And Your Honor asked about if the standard is fundamental error. The standard is still fundamental error here, since defense presented this as one issue, so all of the individual statements should be analyzed under fundamental error.
What about the statement, poor Brandon? Why is that not? I'm not saying that's reversible, but that by itself, I think that's mentioned a couple of times. Is that improper?
It's not, Your Honor. And Judge Soud asked opposing counsel a question about how often defense used the defendant's first name. So
I'm talking about just using his name, kind of meaning poor Brandon, is that improper?
it's not, Your Honor, because it was an invited response based on the defense's closing. So defense's theme of their closing argument was to invoke an emotional reaction so the jury would feel sorry for the defendant, and that's why they would find him not guilty. Here, the state was just rebutting the defense's theme and also what defense had said about state's case. So let me give Your Honor some examples of what defense said about state's case. On page 1255 of the trial transcripts, defense said state's case makes absolutely no sense. On page 1262 of the trial transcript, defense said, so to believe that her heart was stopped for 30 to 60 minutes is outrageous. And on page 1277, defense said, if you believe one of the state witnesses, that's ridiculous. So the state was simply rebutting the defense's theme and what they had said about the state's case, and it was a proper statement because it was an invited response. Next, let's talk about the statement, Mr. Smith can't even tell you why he put the child in the shower.
That's also a proper statement. Again, it's an invited response based on defense's theory of the case. Defense was rebutting the defense's theory, highlighting the inconsistencies, and pointing out that it's not supported by the evidence. The defense's theory was that the defendant gave the child a popsicle, the defendant fell asleep, the defendant woke up and saw a little bit of blood. The defendant gave various different versions about how the little bit of blood got there. He said the child bit her tongue, he said the child bit her lip, he said it was the popsicle, and there was blood on the popsicle wrapper, but yet no wrapper was found at the hotel. The evidence also didn't support why the defendant put the child in the shower if there was only a little bit of blood. If there's only a little bit of blood, why not use napkins? Why not use the sink? Why use the shower when there's no towels, because all the towels are with the mother at the laundromat? So this statement was proper because it was an invited response based, again, on defense's theory of the case.
What about the burden shifting that your opposing counsel raised? Everyone is lying. That's what you would have to believe to find him not guilty.
Sure, Your Honor. So if Your Honors were to find this statement improper, it certainly doesn't rise to the level of fundamental error because of all of the evidence.
Do you agree that that's burden shifting in that case? That's what he argued.
I acknowledge that this court may find it as an improper comment, but even if this court does find it as an improper comment, it doesn't rise to the level of fundamental error. And here's why. There's three main things that support the jury finding the defendant guilty. One, the medical evidence. Two, the defendant's flight from the hospital and the consciousness of guilt. And three, the defendant's inconsistent statements regarding how the injuries occurred. Let's start with the medical evidence first. The child had injuries on their head, face, ears, and neck, somewhere between 6 to 13 different impact sites and injuries. The 2 times the child was left alone with the defendant, the child got injured. The child's cause of death was intentional blunt force trauma, and the number of impact sites combined with the location of the injuries and the severity of the injuries reaffirms that the child's cause of death was intentional blunt force trauma. So it's these injuries that cause the jury to find the defendant guilty, not any alleged improper statements from the prosecutors. The second key piece of evidence for the state to prove why the jury found the defendant guilty is the defendant's flight from the hospital and his consciousness of guilt. So after the defendant learns that the mother's brain dead, the defendant leaves the hospital, he goes back to the hotel, gathers some of his belongings, leaves the hotel. At the hotel, he leaves his passport, his ID, his suitcase, and his car. He hitchhikes to his aunt's house, who he hasn't seen in over a decade, and then the next day he takes a bus to North Carolina. Our third key piece of material evidence that supports the state's case and the jury finding the defendant guilty is the defendant's inconsistent statements regarding how the injuries got there from night 1 and night 2. The defendant gave various different versions of how the child got a little bit of blood, like we talked about earlier. Did she bite her lip? Did she bite her tongue? Was it the popsicle? And the evidence also didn't support why the defendant would put the child in the shower if there was only a little bit of blood. Additionally, any prejudicial effect was minimized by the judge's instructions to the jury. On page 1214 of the trial transcripts, before the closings, the judge instructed the jury that attorney statements are not evidence. You should rely on your own recollection of the evidence, and I will instruct you in the law later on. And then again, after closings, the judge did in fact instruct the jury on the law, such as what is the burden, who has the burden, and what are the elements of the crimes proved. And that is on page 1323 through 1350 of the trial transcripts. So there's no fundamental error given the strength of the state's case.
In response to Judge Boatwright's questions, I think I may have heard you at least perhaps tacitly acknowledge the possibility that comments could be viewed as, certain of the objected to comments could be viewed as burden shifting, but could not those comments also be viewed as evaluating what the defense would ask the jury to conclude of certain evidence and statements offered by the prosecution during the course of the case rather than burden shifting? In other words, the case law is replete with prosecutors are allowed to analyze the evidence, make suggestions to the jury of inferences that can be drawn, things of that sort. And in doing that, perhaps there may be times where prosecutors want to draw attention to either distinctions in the testimony presented to the jury or invite the jury to analyze, you must accept A if you're to disregard B, which seems to be some of the thought process during the course of rebuttal. Do you concede that it's burden shifting, or do you believe perhaps it could also be read as fair commentary on the state of the evidence?
I agree with Your Honor. I think it could be read as fair commentary. It would be the state pointing holes in defense's argument, making logical inferences that this is what the evidence supports and this is what the evidence does not support. And that's proper, as we all know. There's no impropriety in the state pointing out what the evidence supports and what the evidence does not support. But even if this court were to find it improper, it still certainly doesn't rise to the level of fundamental error. And that's because of all the evidence we have in this case to support the jury finding the defendant guilty. Again, that's the medical evidence, the defendant's flight from the hospital and consciousness of guilt, and the defendant's inconsistent statements regarding how the injuries occurred. So given the strength of the state's case here, there's certainly no fundamental error. If the Smith case from the Florida Supreme Court in 2021 is not fundamental error, this case certainly is not fundamental error either. And if the court has no more questions, we ask this court to affirm the trial court's judgment and sentence because the defendant was not deprived his right to a fair trial. Thank you.
Thank you very much.
May it please the court one more time. If you gentlemen were listening, the state said they had 3 points of evidence that pointed to Brandon Smith's guilt. And let me tell you why that's, again, not providing all of the facts, just like what occurred in the answer brief. They suggest that this flight from the hospital is evidence of guilt. If you read the record and our briefs, Mr. Smith and the child's mom agreed that he would go home, and he's seen on the video talking and shaking hands with the front desk. He goes home and gets that information, and then he calls his girlfriend's mother, and his girlfriend's mother say that the police are accusing him of doing something to this child. So he quotes, he's freaking out at this point. He calls the mother 9 times and she does not respond. He calls the hospital to find out where the child is. They do not tell him. So if they want to argue flight, there's equal information and evidence that he is a scared man, has nowhere to go. He has no family around here, and his grandmother, the child, is accusing him of a heinous crime. So that's the first good piece of evidence that the state has quoted you today. The second one was the inconsistent statements. If you listen closely, my opponent is arguing that there was inconsistent statements about her biting her lip and what kind of quantity of blood was on the pillow. That's not an inconsistent statement. He's always said that. And then her other point was inconsistent statement of why a parent would bring a child into the bathtub if they were bleeding. I'm a parent of 3 young daughters, and I would probably do the same thing. I am not a doctor. I don't know what to do when a child's bleeding, but I don't think that's evidence of somebody doing something nefarious to a young girl. The third one was the blunt force trauma. The state made an absolute comment that this was blunt force trauma. That's not what the evidence was in this case. There were 5 experts that testified in this case. One expert said could not tell with any reasonable medical certainty what this happened, whether it was an accident, whether it was a short fall. And sure, there were other experts that said this could have been a blunt force trauma. This was not a short fall. But Dr. Bushbaum, who's an associate medical examiner in Duval County, said this could actually have been a lucid interval where the child suffered an injury, and then the lucid interval, the edema, the hemorrhaging in the brain actually occurred later. And the experts, if you take a look at their testimony, they're saying this injury could have occurred 1 hour to 2 to 3 days after. And we all know that the child hit her head a day before, was throwing up in the mother's car the day before that. So this is not like something sporadically that happened to the child. There is evidence that something happened. So if we go back to Your Honor's question, Judge Soud, when you're talking about the burden shifting, I will quote Jackson versus State, which is 2014 from our Florida Supreme Court. The prosecutor is allowed to critique and counter a theory of defense. What they're not allowed to do, and this is my consistent point, is they're not allowed to denigrate or ridicule defense counsel or their theory of defense while doing it. If you also listen to the prosecutor, they mentioned, well, this was an invited response. But did you hear how many invited responses there were? The defense attorney said that one witness was outrageous, or that the state presented something specific that was ridiculous. What they didn't do is they didn't focus their attention on demeaning and attacking and villainizing the defendant, which has, as everybody understands and acknowledges, the constitutional right to a fair and impartial jury that's dispassionate and objective. And they took that away from this particular juror using that language. This was not a slam dunk case. And the state argues, well, this was overwhelming, the Smith case in the Florida Supreme Court. That's just quite frankly not the law and not the facts of this case. If it was so overwhelming, the jury wouldn't have had these jury questions. If it was so overwhelming, the jury wouldn't have had a guilty verdict that did not include premeditated murder. They thought that he might have abused this child because they found him guilty of felony murder. So if you look at all of these comments designed to say, this guy had to do it because he's a bad apple. He's a poor Brandon. He's trying to say that I'm the victim here. He's trying to say that I didn't do it, but we know he did it. I mean, and if you also noticed, my opponent did not bring up at all the Jackson opinion in 2012, which condemns a detective, two lead detectives, Detective Chandler in this particular case, opinions that the jury heard that this particular defendant was guilty, he was lying to him, and the evidence supported that. That is extremely prejudicial, as the case law says, from this court and the Florida Supreme Court, because of how much credence juries give to police officers, especially a detective who we all know has experience, and they're the ones that we rely on to solve these cases. So if you look at that, if you look at the overall evidence, you look at my opponent's brief, and if you look at our briefs, which explain the context and provide all of the facts of what happened in this case is clearly a fundamental error case, more egregious than fundamental error cases this court has already found. And I would ask this court to issue an opinion condemning these comments and having these comments stop, because they continue to happen in this particular court, as the United States Supreme Court said in Mapp versus Ohio in 1961. The only way to stop comments like this are to put a stamp down, and that is a reversal to say, you must stop this. And that is it, Your Honors, and I appreciate it. Thank you.
Thank you very much, and thank you to counsel, both of you, for well-presented, well-prepared arguments. We will stand in recess.
All right.
Thank you. Just to send to my parents, if you don't mind. It's my first time being official OA, so. Thank you. That would be great if you don't mind. Thank you so much. I'm a former prosecutor. My name is Sheena. Nice to meet you, Greg. This is so much more intimidating than our trial courts.
Is it?
I think so, but I like it.
You got like 3 people?
Yeah, exactly, instead of just one.
Check it out.
Keep it one more, just a little further away. Thank you.
further away or close?
Really further away.
Further away?
Yeah.
Okay. 1, 2, 3. And 1, 2, 3.
Okay. Thank you so much.
You're welcome.
Appreciate it, Ray.
You're welcome.
Perfect. My parents will kick her out. Thank you so much. Tallahassee. Yeah, it's a bit of a drive. Yeah, not ideal. It's like 4 hours with no traffic.
All right.
Yeah.
You safe?
Thank you. The weather's good though, so it should be good.
No, not at all. I just saw you.
Oh, yeah.